Mr. Zhulkarnain, Abdul Rahim.
Mr. Speaker, sir, I rise in support of this amendment bill. At the outset, I declare my interest as an international commercial disputes lawyer. Singapore is a leading international dispute resolution hub because our legal profession, judiciary, and laws are not only leading the cutting edge on the forefront of legal development, but they have also adapted to keep us ahead of the curve to meet the ever-changing needs of global legal demands. I welcome this bill, which seeks to continue to firmly strengthen Singapore's position as an international legal and dispute resolution hub. I will be focusing my speech on the conditional fee agreements, CFAs. The CFAs will increase access to justice for litigants. Since 2017, the law has already provided availability of third-party funding as an option in limited circumstances, for example, in international arbitrations and subsequently domestic arbitrations. There is already a growing trend of alternative funding methods for litigation and arbitration globally. This is especially important given the economic downturn and conservative outlook faced by many corporate clients all over the world. On contingency fees, Professor Patricia Denson, an American economist, stated, quote, "The common allegation that the contingent fees induces attorneys to bring claims with little legal merit has no basis in logic. The fact that the fee depends on winning provides an incentive to screen out issues with little legal merit, an incentive that is lacking with an hourly fee," unquote. Further, various studies have shown that conditional fee agreements or similar arrangements discourage lawyers to take on unmeritorious cases. The CFAs provide a financial disincentive not to commence frivolous suits or claims. However, I do have 5 clarifications for the Minister. Firstly, with parties left on their own to decide on the uplift of finer details of the CFA, will there be some practice guidelines on the quantum of the uplift within the CFA? Now, the bill itself seeks to address this by placing a restriction that the uplift or contingent fee cannot be a percentage of the claim or damages to be recovered. However, should there perhaps be a mandated cap on the uplift in certain circumstances? This is to prevent the uplift from being too disproportionate to what would have been reasonable standard of cost. I appreciate and welcome the fact that lawyers may still be held liable for overcharging under the CFAs, pursuant to amendments under the Legal Professional Conduct Rules. However, as alluded to by members Mr. Murali Pillai and Mr. Lim Biao Chuan, guidance as to how much of an uplift can also provide helpful guidance as to what is excessive or overcharging in a CFA. In the UK, contingency fees or damages-based agreements have been permitted for contentious work in litigation or arbitration proceedings in England and Wales. This means that lawyers can conduct litigation and arbitration in this jurisdiction in return for a share of any damages. Depending on the type of cases, there are differences in the limit of cap for such contingency fee. In this regard, would the Ministry also consider in the future to fine-tune the cap in principles of proportionality, for example, a 50% maximum cap of uplift from the agreed fee? If the CFAs are extended to other categories of disputes, then this cap can be adjusted downwards to reflect the greater consumer or client protection required or the vulnerability of certain groups of clients in the future. A cap may also help to offer the best balance to prevent legal costs from spiraling upwards and at the same time attract the optimal amount of disputes to Singapore. My second clarification is in relation to the resolution of disputes in the CFAs. The new Section 115C states that the uplift fees will not be recoverable from the losing party in respect of party and party costs. Thus, the uplift fees will have to be paid from the pocket of the client to the lawyer. I welcome this amendment as it means that there is lesser risk that CFAs may impact party and party costs and costs of litigation all around. The bill also allows that such uplift in CFAs can also be based on reduced hourly rates instead of a lump sum uplift. This is very progressive and much welcomed. In the UK, the permissibility of such hybrid arrangements was not clear within its legislation and was the subject of an English Court of Appeal case which only recently clarified the position. Now, given the possibility of disputes arising out of the CFAs, can I confirm if lawyers and clients can still refer their solicitor and client fees in the CFAs for taxation in the case of a dispute? This will be more straightforward and cost-effective than filing a separate claim in court or arbitration for a dispute under the CFA. My third clarification is in relation to protection of lawyers entering into CFAs. May I ask and confirm that lawyers agreeing to CFAs would not be held personally liable for adverse party and party costs when acting under such CFAs, unless, of course, if there are circumstances of personal or professional misconduct, in which case that attracts personal liability for costs. My fourth clarification is on the duty of disclosure. To what extent should such CFAs be disclosed by way of statutory or regulatory obligations, for example, through SGAC's announcement or audited yearly financial statements? This is because in an ongoing litigation or arbitration proceeding, such disclosures may cause a certain perception of pressure to succeed on the part of both the client and the party to that CFA. This may impact the dynamics between the two competing parties or conflicting parties in the dispute, for instance. My last clarification is centered on the protection for the client. I understand from MinLaw's press release that safeguards will be implemented in the subsidiary legislation. What are these safeguards to protect a client entering into CFAs, and how long perhaps would be the cooling off period for a client in the CFAs? After a CFA has been entered and, for instance, a client changes lawyers or the lawyer withdraws from the case, what are the safeguards or guidelines to prevent a client being left in the lurch after having already entered into the CFA? Perhaps the ministry can consider a public awareness campaign to assist potential clients on the pitfalls of a CFA and what can be done in the event of a withdrawal or termination of the same. Sir, CFAs may inevitably evoke a diverse set of views and responses among lawyers and users of our legal system. Some view such arrangements as the salvation for the impecunious. Others fear that they open the floodgates of litigation of frivolous claims. However, one thing for certain, the calibrated approach towards CFAs as taken by the ministry in this bill will help cement Singapore as a leading dispute resolution hub in the world. Notwithstanding my clarifications and comments, I stand in support of the bill.